Everyone, welcome to Heritage, and kudos to you for braving the rain. Delighted to be here for a very important panel discussion. To say that the federal judiciary has been a thorn in the side of the Trump administration would be an extreme understatement. Under the guise of issuing equitable relief, federal district court judges have ordered the president to fund organizations that push DEI programs, transgender ideology, and the Green New Deal. Federal district court judges have ordered the military to retain transgendered soldiers, even though it might adversely impact military readiness. Federal district court judges have entered orders prohibiting DOJ from accessing certain information that it needs to advise the president about waste, fraud, and abuse at government agencies. Federal district court judges have ordered the president to reinstate probationary federal employees who are supposed to be essentially at-will employees until they complete their probationary period. Federal district court judges have ordered the president to reinstate employees to key positions within the administration, even though the president does not believe that they would faithfully implement his policy objectives. And federal district court judges have ordered the president to disperse billions of dollars in appropriated funds that will be virtually impossible to recoup if the administration ultimately prevails on its legal claims. These are the kinds of decisions that one might think should be made by the president, who was popularly elected exercising his Article II authority, rather than by a single Article III judge. Moreover, these district court judges have not just ruled in favor of the parties appearing before them. They are granting relief in the form of nationwide injunctions that also provide relief to individuals all across the country who are not parties to the lawsuit. And even when judges in other districts have reached contrary conclusions, and they are doing this at an astonishing rate. Although a strong argument can be made that nationwide injunctions are illegal to begin with, they are, at the very least, supposed to be rare. 2/3 of all nationwide injunctions issued over the last 25 years were issued during President Trump's first term. In less than 3 months, federal district court judges, overwhelmingly Democrat appointees from the bluest of blue states, have issued 17 nationwide injunctions against the Trump administration, compared with only 14 that were issued over the entire 4 years of the Biden administration. The president's supporters have proposed various ways to address these problems, including eliminating the ability of lower court judges to exercise jurisdiction over certain types of cases, such as national security cases, defunding the lower federal courts, limiting the ability of district court judges to issue nationwide injunctions, and impeaching some of the judges issuing these decisions. We have an outstanding group of experts with divergent perspectives here to discuss these issues. I'll invite them to the stage now while I introduce them. The first person that you will hear from is my colleague, Hans von Spakovsky. Hans is a senior legal fellow and the manager of the Election Law Reform Initiative in the Mies Center here at the Heritage Foundation. Hans is a widely known and widely published legal scholar and commentator on a range of issues. He's a former member of the Federal Election Commission and also served as counsel to the Assistant Attorney General for the Office of Civil Rights within the Justice Department. Prior to entering public service, Hans worked for several years as a government affairs consultant in corporate legal departments and in private practice. He's the author of 3 books: Who's Counting? How Fraudsters and Bureaucrats Put Your Vote at Risk, Obama's Enforcer, Eric Holder's Justice Department, and Our Broken Elections, How the Left Changed the Way You Vote. Then you will hear from Professor Jonathan Turley. Jonathan is the J.B. and Maurice C. Shapiro Professor of Public Interest Law at George Washington Law School. He is a nationally recognized scholar and legal commentator who has also written and spoken on a wide range of legal issues. He's written more than 36 academic articles that have appeared in prestigious law journals such as Cornell, Duke, Georgetown, Harvard, Northwestern, among others. He recently wrote a book that I commend highly to you, The Indispensable Right: Free Speech in an Age of Rage. He's also served as counsel in some very notable cases, including national security and terrorism cases. He has testified a number of times before Congress, including in several impeachment hearings, and he acted as part of the trial team defending federal judge Thomas Porcius during his impeachment removal trial in the Senate. Third, you will hear from Mike Davis. Mike is the founder and president of the Article 3 Project, which defends constitutionalist judges and the rule of law. Mike previously served as chief counsel for nominations to the Senate Judiciary Chairman, Chuck Grassley. In that capacity, Mike advised senators on the confirmation of federal judges and senior executive branch appointees, overseeing floor votes of 278 nominees, including the confirmation of Justice Brett Kavanaugh. In addition to having served a stint in private practice, Davis has worked for President George W. Bush, the Justice Department, House Speaker Newt Gingrich, and Justice Neil Gorsuch. And he also led the outside support team for Justice Gorsuch's successful confirmation to the Supreme Court. Please join me in welcoming our panelists as they come to the stage. And then, Hans, you're up first.
Well, welcome to Heritage, all of you who braved the rain to be here this morning, and we have a huge crowd also watching virtually, so I welcome you here too. We're here about a very serious topic, but I actually thought that on March 28th, the Babylon Bee had a great title for one of their articles that kind of captured this whole story. The title is, Trump leaves presidency to become even more powerful district court judge. This is not a new problem. I actually testified in front of a House Judiciary Subcommittee on this topic in November of 2017, 8 years ago. And the problem has just gotten exponentially worse since then, particularly in the last 3 months. There are four things, I think, going on here. One, judges are frankly abusing their authority. They're not following Supreme Court precedents that lay out the rules for nationwide injunctions. They are violating the procedural rules that govern their actions. And unfortunately, the Supreme Court has failed to take actions to stop this abuse. John went through some of the numbers, but last year, I think it was a Harvard Law Review, did a study about that. Since 1963, there have been 127 nationwide injunctions, without counting the 17 this year. Before that, they were virtually unknown in our judicial history. There were 96 from 2001 to 2023, 64 in Trump's first term. Why has that happened? Well, my personal opinion is that if you look at their advocacy, if you look at their publications, and most importantly, if you look at their social media rantings, I guess is the word, quite frankly, the judicial nominees who were put forward by Barack Obama and Joe Biden and confirmed are some of the most left-wing partisan ideologues who have ever sat on the judiciary in American history. Now, all of us realize Article 3 provides the most limited power of the three branches to the judicial branch. Its job is not to determine policy. It's not to substitute a judge's opinion or preferences on the public policy of Congress or the president, and it's certainly not to substitute a court's judgment over that of the chief executive on matters arising and ranging from national security to foreign policy to war-making powers. It's limited to adjudicating cases and controversies in law and equity arising from the Constitution, the acts of Congress, and treaties. Nowhere in Article 3 does it say that the judges have the same legislative power as Congress or the same executive authority of the president. They can't enter a judgment that's comparable to the laws created by Congress and enforced by the president. Now, there are two important Supreme Court cases on this that almost all of these judges are violating. The first is a case from 1980 called Williams versus Zabarez. And in that case, the Supreme Court said that district courts lack the jurisdiction to grant relief to a party over an issue not in dispute in the case and unnecessary to remedy the actual injury that they suffered. The second case, and this is the one that's most important, is called U.S. versus Mendoza. This is from 1984. And I hate to bring up, these legal terms, but basically the Supreme Court said collateral estoppel does not apply to the federal government. What that means is that an adverse judgment against the government by one specific named party or plaintiff does not mean that all similar individuals can use that adverse judgment against the government. The simple way to understand that is if I sue my credit card company in Virginia and the court says, yes, credit card company, you violated this specific statute, and therefore Hans von Spakovsky wins his case. If somebody else who was not in my lawsuit sues my credit card company, they can use that judgment where a court's already said they violated the law. They can use that in their case. And the credit card company can't come in and say, oh, didn't violate the law. That rule does not apply to the U.S. government. If the U.S. government loses a case to specific parties or plaintiffs in a case in Virginia, that adverse judgment cannot be used against them on the very same issue, the very same law down in a case in Alabama. And the reason for that is the Supreme Court said the government's too large, deals with too many legal issues to allow one federal district court to hamstring the entire government. There's no percolation of decisions. The whole point of our appellate system is if you get judges and courts in one state to decide one way and judges and courts in another state to decide another way, eventually gets to the Supreme Court, and the Supreme Court has the benefit of the arguments and decisions made in the different courts to decide what the correct course of action is. And we have hundreds of federal district court judges, so if you allowed collateral estoppel, it would lead to extreme forum shopping. And that's exactly what we've seen happening. We've seen a judge, for example, in Northern California issue a decision affecting federal employees located in the District of Columbia. Now, the other important issue here is that almost all of these judges are violating Federal Rule of Civil Procedure 65C. Now, the Federal Rules of Civil Procedure, those are not suggestions. Those are ironclad rules that govern how judges operate in their courtrooms. And Rule 65C says this, that a party seeking an injunction must put up a bond to cover the costs and damages of the party against whom the injunction is issued in case the injunction is later found to have been wrongfully issued. This is not discretionary. The judge can't put in just some nominal bond amount. The language in the rule is that injunction can be issued only if, that's the exact language, if a bond is posted. In the Judge Boasberg case, he didn't require any bond at all, which I think potentially makes his orders invalid. The Maryland versus USDA case, you all may have seen this. Federal judge there ordered Trump to rehire 25,000 probationary employees, and what bond did he require? $100 an employee. The estimated cost to rehire these probationary judges and employees and pay them for 1 month is $45 million. And yet, Judge James K. Brader said, well, there's a public interest exception to this rule. There's no public interest exception to this rule. He is blatantly violating the rules that go with this. unless a judge goes through the very rigorous standards under another federal rule, there's a federal rule, Rule 23, that sets up the rules for a class action. That's an action where you actually are representing a whole series and classification of individuals. There are very strict standards for that. The judges are not following that either. I think the best comment on this whole situation was recently issued by Justice Alito in a dissent. And if you all didn't see this, March 5th, Department of State versus AIDS Vaccine Advocacy Coalition. It was a 5-4 decision refusing to grant a stay of the lower court's decision. It was Alito writing the dissent, joined by Thomas, Gorsuch, and Kavanaugh. And here's what Alito wrote. Does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay and probably lose forever $2 billion taxpayer dollars? The answer to that question should be an emphatic no. But a majority of this court apparently thinks otherwise. I am stunned. I think the American people are also stunned by the seizure of power by unelected judicial rogues who are thwarting a president who was elected by the American people and stopping him from carrying out the promises that he made. We constantly kept hearing, prior to the last election, the theme of a threat to democracy. Well, I can't think of a greater threat to democracy than what these judges are doing. Thanks.
Oops. I'm so sorry. You took so much care to put this on me, and I blew it. Thank you so much. It's a great pleasure to be here at Heritage, also to be with not just 3 great thought leaders, but 3 great friends of mine, and to talk about something that is enormously important. It's a strange thing for me to be in this controversy as a commentator, as an academic, because I'm a Madisonian scholar, so I tend to favor the legislative branch in a lot of fights with the executive branch. And so this has really thrown me off my game, because it seems to me that the president has some legitimate complaints here. I've been critical of both sides, and I'll be critical of both sides today. But for the most part, I agree with the administration that the overall injunctions issued against it are not valid, and I believe that they will ultimately fail. Many have already failed on appeal. You know, I remember when I was clerking on the Fifth Circuit, I listened to a new young circuit judge being sworn in. There was an old crotchety Texas district court judge from the border listening. This was decades ago, and this judge really gave this incredible speech about all the things that he wanted to achieve, and I could see this Texas judge sort of moving in his seat uncomfortably, and after it was done, the Texas judge went up to him and said, "Son, I really enjoyed your speech, but I really think you need to think about one thing." And he says, "What's that?" And he says, "You've been appointed, not anointed." And I think that is, of course, a problem with many judges throughout our history, that they have overstepped. And as a Madisonian scholar, you know, I've written a lot about Madison's view of Article 3. And one of the most fascinating things to come out of Madison's work, and this includes work at Princeton, where I looked at some of his records from Princeton, which really sort of made you hate the guy because no one should be that smart as a freshman. And what was the hottest thing of its day was Newtonian physics. That was the thing. That's what everyone was talking about. And Madison, as a freshman, was obsessed with Newtonian physics, and even to the point of drawing up this constellation of planets, all locked in orbits around stars, just hundreds of them, just an extraordinary constellation. But when you look at the later constitutional debates, you see in Madison's words a lot of Newtonian references that he views the three branches like three planetary bodies locked in orbit, that you have these equal planets that achieve stability through this sort of gravitational pull, this normally negative sort of reality between three large bodies. The danger that we see today is when you have one branch that tries to grow larger. It creates an instability. You lose that orbital pattern. And I think we are certainly seeing that. I find it odd that some of these judges believe that the President of the United States cannot reduce the size of government, look for fraud or waste, even at an unprecedented rate in an unprecedented way. Now, I give you that this was really a shock to the system. That's what Elon Musk is. You know, the theory is that if you throw a badger into a crowded car, people will get out. And Elon Musk is that badger. And people got out. And that was obviously their intention. But I don't see, as a Court of Appeals, the First Circuit recently said, unconventional doesn't mean unconstitutional. Where I've been critical of the administration is often on the rhetoric, and I think it has committed some unforced errors. And they've got to really pick the hills to fight on. This administration is in better shape than what I saw in the first administration. It has a plan, and it is trying to achieve what are really quite impressive goals. You can agree with them or not, but they are the goals that he ran on, that he was elected to fulfill. I do not support calls for impeachment of these judges. You know, in the case involving the Venezuelan deportees, that is a long controversial law, rarely used, being used in a very novel way. Reasonable people can disagree. We have a wonderful system in which we can hash that out. Every administration that has followed the other party, including Joe Biden, have come in and wiped the slate clean of executive orders. And what follows is litigation. And it sorts its way out. In the majority of cases, presidents tend to prevail. In some cases, they won't. That pattern will remain the same with President Trump in this term. But impeachment is not the answer. It is the old military adage that if all you have is a hammer, every problem looks like a nail. It's not a good way to deal with this problem. And with other appellate courts siding with lower courts, the question is where do you stop at this when you go down that road? I also don't agree with limiting jurisdiction or limiting funds. I believe we have the world's greatest judicial system, and it's working. Injunctions have been lifted. The Supreme Court just recently, again, ruled in favor of the Trump administration. That's the strength of our system, and we can have faith in it. Now, my criticism of these trial judges is that, you know, when Biden came in and wiped out all of the Trump executive orders, I don't remember all of these injunctions coming up because they didn't occur. And these judges are really following Oscar Wilde's rule that the only way to be rid of temptation is to yield to it. And they have been issuing these national injunctions. Even liberal justices like Justice Kagan have said, this is insane. That is, and what's interesting is that Roberts has said this, they've all said this in oral argument. In my view, part of the problem is that Roberts often believes that people will come to the right decision over time. And so they have said for years, stop the national injunctions, and it hasn't worked. And so now Congress is going to have to step in. I think it would be a good thing to tweak the language for injunctions and possibly limit the ability of national injunctions. I personally would like to see, there'll be some cases where a national injunction may be appropriate depending on the case, if you've got a class action. I'm not too sure how we would handle that. But I would like to see, at a minimum, any class action have to go through a separate 3-judge panel with very narrow conditions under which a national injunction can be held. I would also like to see Congress collapse the time for appeal. The problem that we've seen, and again, I really am sympathetic with the president on this, is that they issue a TRO, which some courts do not believe is appealable. That goes for 2 weeks, then it converts into a PI. And then you pretty much have a green light to go and appeal. The problem is that 2 weeks is a heck of a long time if a president believes that there's a national security problem here. And I think that Congress can help by collapsing that period, allowing for immediate appeals to really speed this along. So the point of all of this is simply, there are ways here to deal with the problem. We can work the problem. Do I feel that that most of these judges are wrong? Yes, I do. I think they're wrong on the law. But we can use our system. You know, at the end of the day, the Madisonian system is a leap of faith, you know, and it's very common for people to have a crisis of faith. When we're very angry at each other or we're very afraid, we have a crisis of faith. But we have every reason to trust this system. We have the oldest, most stable constitutional system in the world. It's working right now. It is reversing a lot of these injunctions. And I think we can take faith in that. Thank you.
President Trump campaigned on the fact that he is going to hire Elon Musk, set up the Department of Government Efficiency, or DOGE, secure our border, and get illegal immigrants, particularly foreign terrorists, the hell out of our country. And President Trump is doing the unthinkable in Washington. He's actually delivering on his campaign promises, and he's doing it very fast. And President Trump got a broad electoral mandate. He got 312 electoral votes, all 7 swing states, the popular vote, and he kept the House. He won a comfortable majority in the Senate. He has the mandate from the American people. And President Trump is not stealing legislative power from Congress under Article 1. President Trump is not stealing the Supreme Court's judicial power under Article 3. He is exercising core Article 2 power. He's hiring, he's firing, he's repelling an invasion of our country. He's cutting waste, fraud, and abuse. And these activist parties are running to activist judges who do not have jurisdiction, and they are issuing these injunctions that are unlawful, clearly unlawful. This is not judicial review by these activist judges. This is judicial sabotage of the presidency, and it's unacceptable. And I disagree with my friend Professor Turley on what we need to do about it. I actually think that we need to take a very aggressive approach to this judicial sabotage. I'm working right now with Senator Chuck Grassley's team, the chairman of the Judiciary Committee on Legislation. I'm working with Senator Mike Lee. I'm working with members of the House. We need to hold these judicial activists accountable for this judicial sabotage, because I would say this to the. Let me give you 2 cases that are the red lines that these judges crossed. Judge Ali is a new judge on the D.C. District Court. He got confirmed by the slimmest of margins after the election. He got rammed through by Chuck Schumer in the lame duck session, right? He is a radical. He is a radical judge. He brags he's the first Muslim, the first Arab judge on the D.C. federal court. He's still a Canadian citizen. I don't know how you can still be a citizen of a foreign country and be a federal judge, but you know the Democrats thought that was acceptable. And Judge Ali thinks that he has the power to order $2 billion in foreign aid to go out the door over the President of the United States National Security Review, to make sure, for example, that we're not funding Hamas terrorism that will kill Americans under the guise of Gaza and humanitarian relief, to make sure we're not funding waste, fraud, and abuse like transgender mice research in Durka land, wherever the hell we were spending money on transgender mice. And Judge Ali issued a temporary restraining order. I don't know how a temporary restraining order works, where you send $2 billion out the door and it's never coming back without a bond that we were talking about under Rule 65C. And so $2 billion goes out the door, right? And who knows where this is going? I mean, it literally could be funding Hamas to kill Americans. And it gets to the Supreme Court, and in a shocking decision that they talked about, where Justice Alito writing a scathing dissent, the Chief Justice and Justice Amy Coney Barrett join the three liberals and let this money go out the door, right? And I think the rationale for Professor Barrett, when she's a civil procedure professor, is she says, well, the judge called it a temporary restraining order, so that's in my when I'm grading civil procedure exams, that's not immediately appealable, even though it wasn't a temporary restraining order. It was obviously an injunction that's money's never coming back. And so that weakness at that pivotal point by the Supreme Court is what has emboldened these activist judges across the country for the last many, many weeks. And it got to the point where, I think it was 4 Saturdays ago, you had President Trump working with El Salvador, the president of El Salvador, on a military intel and law enforcement operation to get the most dangerous terrorist in the Western Hemisphere, Tren de Aragua, out of our country. The president had a finding under the Alien Enemies Act of 1798 that these Tren de Aragua terrorists are working with the Venezuelan government to sabotage our country, which is exactly what they're doing, right? So President Trump ordered them deported under that act and get them out of our country, send them to El Salvador. El Salvador agreed to take these terrorists and MS-13 gang members, right? Judge Boasberg is this DC judge who did not even have the emergency docket that weekend, right? He took it on himself to go open up his courtroom on that Saturday and he exposed an ongoing military operation, which put American and allied lives in grave danger, right? And then he, regardless of what you think about the law on the Alien Enemies Act of 1798, whether it was permissible or not permissible for the president to do this, Judge Boasberg certainly did not have the jurisdiction to open up his courtroom and expose an ongoing military operation, right? When these planes are over the Gulf of America, and then Boasberg actually ordered the Trump administration to turn around these planes, right? He doesn't know the fuel levels. He doesn't know the security footprints in America. We saw the security footprints in El Salvador. They had hundreds of military, intel, and law enforcement officials ready to take these terrorists, right? Why would we have that same footprint in America after the planes took off? Why would we think some activist judge in D.C. would take it upon himself to order these planes turned around, right? And so, fortunately, that order was ignored, whether willfully or not, who knows. But those planes landed, those terrorists are in El Salvador, and now Boasberg thinks he's going to hold the Trump administration in contempt for not turning around those planes. I would say this, he didn't have jurisdiction over this case at all. It wasn't his emergency docket that weekend, and the D.C. District Court was not the proper court to bring a claim. If these terrorists have a claim, it's a habeas claim in Texas from where the planes took off. It's not a D.C. District Court judge with no jurisdiction over this case issuing this dangerous temporary restraining order to turn around planes, right? And think about this. Think about how much of a sabotage that is of the presidency. If you're not only do we not have the security footprint in place to return these terrorists back to America, think about this. That Salvadorian president took a big risk to work with President Trump on this operation, this military operation to take these terrorists. He has hundreds of people waiting for these terrorists in El Salvador. If those planes turn around, this president is humiliated among his military, intelligence, and law enforcement leaders. That affects the president's ability to conduct foreign affairs. Why would a foreign leader want to deal with the president of the United States if some goofball judge in D.C. is going to turn around the planes and embarrass the president? So, look, this is what I've been saying pretty publicly, that the Chief Justice, and look, I clerked for Justice Gorsuch. I know the Chief Justice. I think he's a good guy. But I would say this to the Chief Justice, the legitimacy of the judiciary is on the line on this case, with Judge Boasberg holding the Trump administration in contempt. I hope Boasberg has Green Berets as law clerks, because I don't think these terrorists are coming back to America. So unless Boasberg sends his Green Beret law clerks to go get them, once the judiciary loses its legitimacy, it loses everything, right? It has nothing but its legitimacy. And so if Boasberg issues an order holding the Trump administration in contempt, and the Trump administration ignores the order, as they should, then what? Then what? We've taken the country to the brink with this order. I think Boasberg needs to step back on this. He needs to, if people were wrongfully detained and sent to El Salvador, they can file a habeas petition. But for this Boasberg to run and expose a military operation, endangering lives, and then damaging the president's ability to conduct foreign affairs is unacceptable. It's a red line, and that's the reason I have called for the impeachment of Judge Boasberg. I have called for the Trump administration to ignore his order. I've never done this before. I've never called for anyone to ignore a judge's order. But when you have an order that's so lawless and so dangerous to our national security like Boasberg's, this is the red line. And so the Supreme Court is considering this case right now in the emergency docket. I hope the Chief Justice and Professor Barrett understand how much is on the line here. This isn't grading law school exams at Notre Dame. This is a very serious matter for the judiciary's legitimacy. So thank you.
That you heard. Hans, Jonathan?
I actually agree with Mike that the Venezuelan case is a habeas case. It's a very weird case. It came up, there was an indication they were moving it under habeas. Then they did a sort of APA type of attack under the Administrative Procedures Act where I don't think it fits. The interesting thing is that if it had been moved forward under habeas, the challengers would have lost rather handily. They can't prevail on this as a habeas, in my view. But the most curious thing about that case is that even when it made its way up to the Supreme Court, even the court didn't know what the case was. That is it a habeas case? Is it an APA case? How it came up? My guess is that they could very well take an off-ramp on this and just say this is just a lot of broken china and we're not going to be pasting it back together. Mike and I disagree, obviously, on the response with judges like Judge Boasberg. I agree with the criticism of Justice Barrett on the TRO. I do think that it's rather curious to treat a TRO as a TRO when this is a one-stop case. Once that money goes, it doesn't come back. But if I have a criticism of Barrett, who I have a lot of respect for, even though I disagree with some of her decisions, she does tend towards the minutia in oral arguments, particularly. It may be in fact a signature of a law professor. Law professors tend to do that. But she's a very fine justice, but I disagree with treating it as a TRO, because I just don't see how you can treat a TRO when there's nothing else but the TRO that will ever be reviewed, because it ain't coming back.
Let me just mention one thing. Look, the president, if you read the executive order very carefully, the president goes through a lot of details to designate this Venezuelan gang as a terrorist organization. That is not something that that can be appealed. Okay, under the statutes governing this, the president's designated them as a terrorist organization. That then brings into play a very specific federal immigration statute. There's a federal immigration statute that gives the Attorney General, therefore the president, the power to deport certain aliens that fall into particular classes. There's a whole list of them. And it's everything from individuals who engage in criminal activity that endanger public safety, such as some of these students at Columbia. But there's a whole section on if you're a member of a terrorist organization, if you support or espouse support for a terrorist organization that gives basically the Attorney General to yank you out of the country. And Boasberg seems to just kind of be ignoring those parts of the law that give the government, like really summary authority to be able to take members of terrorist groups and those who support terrorist groups, even if they're not a member, out of the country. And that's just an additional authority that the president has to do what he's doing.
I would say this, that the president has the absolute power, he has the absolute duty under Article 2 of the Constitution to repel an invasion. And any statute, regulation, court order that gets in his way is clearly unconstitutional and should be ignored. The president is the commander-in-chief. He has the duty to protect our country from invasion, and that's exactly what he's doing with Tren de Aragua.
Yeah, this is where I think it's probably my greatest disagreement with Mike, is that we can't go down that road. That this argument was made by Stephen Miller that they believe that this is non-justiciable and therefore they don't have to comply with the court order. I think that would be a terrible mistake for the administration, both practically and constitutionally. We are a nation of laws. This is not the first president's disagreed with a trial judge. It's not the first trial judge that might be demonstrably wrong. The response is you appeal that judgment. Because if we go down this road and presidents can simply say, well, I'm right, this is a core Article 2 duty, you're going to have the next president, a Kamala Harris or someone else who says, well, I'm also right about this. And they will also ignore this rule. The fact is, Article 3 is almost a work in progress. I always tell my students, if you read Article 1 and Article 2 first, you're left with this curious thing about Article 3, because the first two articles are incredibly detailed, and then Article 3 reads like, there shall be courts. And it was portrayed by Alexander Hamilton as the least dangerous branch. I don't think any president would agree with that. He said it has the least tendency to annoy a president. I'm sure no president would say that. But presidents, despite all of the bravado, even presidents like Jackson, have yielded because it's in our DNA. We respect the court system. And I would strongly encourage the Trump administration not to go down this road. And by the way, on a practical level, you're making a serious mistake. I think that you're going to really tick off some of the justices that you are going to need for other things. You're going to win these fights. Win the fight. But if you want to take the shortcut, you're going to lose critical votes on the Supreme Court, and it's going to put your agenda into danger because you will become the threat for some of those justices.
So you all raised some excellent points. I mean, so Mike, you referred to the legitimacy of the judiciary being on the line. You also raised the point that some of the orders that Chief Judge Boasberg entered can impact on foreign relations. Certainly would have been embarrassing to President Bukele if that plane had turned around. And you're also, of course, all suggesting that there's a certain degree of judicial modesty that ought to be involved, not only in terms of not entering orders beyond your jurisdiction or reaching out to grab a case when it's a habeas case that properly lies in another jurisdiction, but being aware of the fact that you don't sit in the Situation Room in National Security Council meetings and hearing all about classified information that the president has to take into account when he makes these decisions. I want to bring this down just a little bit. So there have been several discussions about the case in which the district court judge here in the district ordered $2 billion as part of a TRO to go out the door, and the Supreme Court denied issuing a stay with the Chief Justice and Justice Barrett joining with Justices Kagan, Sotomayor, and Jackson. Over the weekend, or late last week, there was another case that went up for a lot less money, but nonetheless, same kind of principle, and Justice Barrett flipped, and a stay has now been issued. And I'm wondering whether you have any thoughts about perhaps what's going on there, or whether there's some regret about the first decision, or sort of gauging public reaction. What do you think is going on?
You want to go first?
Sure. I think that Justice Barrett was a rattled law professor before, and she got unrattled. I think she came to Justice Alito's side in his scathing dissent several weeks ago that unleashed this judicial sabotage across the country for several weeks, that just because an activist judge calls it a TRO doesn't mean it's a TRO. You have to look at the result of the order, not the label of the order. And she finally, Professor Barrett finally figured that out, which I think was important, and I think it was a very important step to get the Supreme Court getting its judicial house in order.
You know, if I could say something about the $2 billion, what was so bizarre about that opinion was that, look, when this was USAID money. Well, when Congress appropriates funding for USAID, the funding doesn't go over there with deadlines. You know, they don't parcel it out saying, okay, this money has to go by April 1st, this by April 5th, this by April 10th. They sent a chunk of money over to the State Department, and the Trump administration comes in and suspends all payments. This coalition group gets together, sues, and says, well, we're owed $2 billion for a grant, and the judge orders it paid within 36 hours. Where does he get a deadline for 36 hours? There's no such deadline in the appropriations bill that sent the money over. I mean, that showed the extremeness, I think, of the judge's opinion in that case.
I say this, the federal and Professor Turley's going to disagree with me on this one too. The federal judiciary has a $10 billion budget for FY 2025. So let's take $2 billion out of that budget until the Supreme Court gets its judicial house in order. That's a 20% cut to make up for Judge Ali sending $2 billion to his terrorist buddies.
And I want to say I agree with Mike that I strongly disagree with that.
So you also mentioned, several of you mentioned that at various times, several justices in individual instances have decried nationwide injunctions. My colleagues, Giancarlo Canaparo and Paul Larkin, have written an article saying, look, there's no jurisdiction for that. It's unconstitutional. There's no case or controversy to issue an injunction that favors non-parties to a litigation, with the one exception being if a class has been certified, a class action has been properly certified under Rule 65, or Rule 23, I'm sorry. Short of that, the justices have still not, the 4 or 5 of them have mentioned this, gotten together in an opinion and said, this is wrong. You know, why that hesitation? Why haven't they done that? Or why hasn't the Judicial Council weighed in on this?
It's a curious thing. I was actually talking about this in my Supreme Court class at GW, because we looked at the injunction case. And for someone who covers the Supreme Court for the media, for the last, I would say almost 10 years, the justices have been issuing very clear warnings to the district courts saying, stop this. We don't like these national injunctions. They're not, you can't run a government this way. And they have been actually lifting the injunctions, right? So they've been countermanding these judges, but they didn't go any further than it, as you mentioned. They didn't put in an opinion, any type of guidelines. I think that, you know, I adored Chief Justice Roberts as a person, and also I think that he was born to be Chief Justice. I think I can't imagine him being anything but a Chief Justice. I think in the nursery there was one baby saying, okay, all you cry, now all you cry, now let's all cry together, and that was Roberts as an infant. He's just perfect for the job, and I don't know anyone that doesn't like him in that sense. My only complaint is that it's not just being an incrementalist. He tends to really expect people to come along, and he doesn't bring the hammer down. And I think this is an example of it. I think the Supreme Court should have taken this on in writing, as you said before, and this is a classic reason for Congress to intervene. I mean, they've given the court over 10 years, the court's been identifying this as a problem, and so I do think that Congress has every right now to move forward.
Yeah, and we should mention what the intervention is. I mean, both, and like you mentioned, Senator Lee and Representative Issa have put forward bills that would require these kind of lawsuits against the government, particularly executive actions of the president, to go to a 3-judge panel, and then they would have a direct appeal to the U.S. Supreme Court. And I've heard some people say, oh, well, we shouldn't do that. That changes the whole procedure. There's actually precedent for this.
Yes, there is.
When the Voting Rights Act was passed in 1965, they set up a system. I mean, I guess I can say this now. They didn't trust some of the federal judges in the southern courts who had been put forward by the Democratic Party that they would rule the right way on certain voting cases, and so they set up a system of a 3-judge panel with a direct appeal to the United States. And so we've done this before. It's something that could be done again.
And remember, these parties have redress, right? If you're a fired federal employee and you think you were fired for the wrong reasons, you can go to the Merit Systems Protection Board, right? If you're a federal contractor and you think your contract was terminated for the wrong reasons, you can go to the Court of Federal Claims. But this idea you can go to an activist judge and get a nationwide injunction sabotaging the president's Article 2 power, even for a day, let alone 2 weeks or a month, this is unacceptable what these judges are doing. And I don't want to hear about percolation and we're going to let the president not be able to do his job for 2 weeks or 2 months or whatever. Imagine if you told a judge that you can't, I'm sorry, we're going to put a temporary restraining order on your ability to be a judge for 2 weeks. Would that be acceptable? Or a member of Congress, sorry, you can't legislate for 2 weeks. How can you tell the president he can't exercise Article 2 powers for 2 weeks or 2 months? It's unacceptable. This is a sabotage of the presidency, and that's why my response is a little bit more bold and out there than others.
It's interesting because you talk about the Merit Systems Protection Board, Court of Federal Claims, these specialty courts that are designed to talk about contractual disputes. That featured prominently in Justice Alito's dissent from denial in the USAID case. So presumably it was not convincing to Justice Barrett at the time, but at the recent order, saying, well, if you have a complaint, take it to the Merit Systems Protection Board or the Court of Federal Claims. Don't file in district court, appeared. I want to ask a little bit about this injunction remedy. I'm sorry, impeachment remedy. What's the argument that it meets the standard for impeachment under the Constitution? That's one question. And I guess a second question that I would ask is, since the 1960s, we've had a lot more time in which the Democrats were in control of the White House and the House and Senate and than the Republicans. Are you not concerned that the next time there is a Democrat trifecta, that this tactic would be used against Republican-appointed judges?
So, for example, when the Democrats organize illegal obstruction of justice campaigns outside of the Supreme Court justices' homes, leading to them going to safe houses and leading to a 1 a.m. assassination attempt against Justice Kavanaugh, his wife Ashley, their 2 teenage daughters. For me, the Democrats have shown that they're not going to operate in good faith when it comes to judges, and we need to put on our brass knuckles and start fighting back. The impeachment standard to me is when it is so clearly lawless, like what Boasberg did 4 Saturdays ago, and when it's so dangerous to our national security. And I think, again, I've never called for a judge's order to get ignored. I've never called for impeachment. I think this was such an egregious case. And it was not his interpretation of a statute that was egregious. It was his opening up his courtroom, exposing this ongoing national security, this military operation, endangering lives and ordering planes to turn around when, he doesn't know the fuel levels, he doesn't know the security footprint, he's not equipped. He thinks because the Chief Justice put him on the FISA court that he thinks he's going to play commander-in-chief on a Saturday, and it's just unacceptable what Judge Boasberg has done.
I obviously disagree with Mike on that. First of all, the question is, where do you end? Judge Boasberg was upheld by the D.C. Circuit. You're going to impeach them too? I mean, they agreed with his reasoning. Now, I happen to think that the reasoning of many of these judges is fallacious. I think, with the TRO on the $2 billion, I think that Barrett was wrong, Justice Barrett was wrong. She should have acknowledged that this was not a TRO. And quite frankly, the district judge in that case was gaming the system. The judge knew exactly how a TRO is generally not appealable, and that the time set would make it impossible to get this money back. And you should be able to take judicial notice of that fact. But in terms of Judge Boasberg, he was upheld. So do you impeach him? Do you then impeach the justices that vote for him? The fact is that these are issues that people of good faith can disagree about. I think that Judge Boasberg took the wrong approach in this case. I think he should have stepped back and tried to resolve this. But he turned this into a fight between Article 3 and Article 2 and the authority of the two branches. Now, that escalation I don't think was necessary, but I don't see how you can do this. And I must say, I was lead defense counsel in the last judicial impeachment in the Senate. It's a horrible process. It's a horrible process to be lead counsel on because you have a 100-member jury, most of which you would strike for cause in a real trial. I mean, half of them were either previously indicted or seemed on their way to being indicted. And it's a terrible, terrible process. It also is disjunctive for the Senate and for the legislative process. It takes a lot to get through this stuff. But most importantly, we have to have some breathing space for disagreements. Yes, I agree. Mike and I are in agreement on the lawfare issue. We took the same position on many of those cases against Trump. They were raw lawfare. But we can't let this become a race to the bottom. We have too much at stake. At some point, mature minds have got to say, you know what? We're going to go back to regular order. We're going to use our system. We're going to have faith in it, and we're going to let it work.
So in a moment, I'm going to open it up to questions from the audience. So okay, I got one. You're going to get there first. So you get the first question. You'll get the second one. Early adopters. In terms of, we had various solutions discussed as, impeachment. And it is worth saying that even though there are constitutional standards for impeachment, it is essentially a political process. No judge is going to weigh in and overturn the decision of either the House to impeach somebody or the Senate to convict somebody.
I would say this, if Judge Boasberg is sitting through impeachment proceedings, he's not going to moonlight as the commander-in-chief on a Saturday.
Fair enough.
Let's make the process the punishment.
I'm curious, so you mentioned the ISA bill and Mike Lee and Chuck Grassley's introducing a bill. Do you think, in light of the fact that Democrats have had their ox gored during, when Biden was in office, not as often as Trump has had his ox gored through nationwide injunctions, do you think the votes might be there to pass something to reform nationwide injunctions from the legislative standpoint? And if not, do you think that the Supreme Court will eventually step in?
I actually think that if Congress doesn't move, the court is likely to use the next opportunity to try to rein in these district court judges. I think that Roberts, Kavanaugh, and others realize they let this thing go on too long. You clearly have 5 justices that have spoken publicly against this. You probably have more. So I would expect that if Congress doesn't act, you'd finally see some action. It's belated. They should have done it before. But I do think you'll see some action.
Yeah, I mean, it's clearly Article 3. The Article 3, the judges don't have power to decide cases for non-parties. The judicial power is parties before the court who have redressable claims. And if you're not a party before the court, or if you don't have a redressable claim, there's no judicial power. And the Supreme Court could fix that today.
First question, hold on, wait for a microphone to come to you. We have interns on both sides of the room, so if you raise your hand, the second one will go there.
Mike, could you tell us who brought the case to Boasberg and why?
It was, I may need Professor Turley to jump in here. It was a plaintiff, was it like a immigration organization?
I do think it was an organization.
Like just like a nonprofit, an NGO organization suing on behalf of a Nicaragua terrorist, apparently. So who knew they had such good lawyers? It's amazing to me that we suddenly care about due process rights for foreign terrorists when the Biden administration politicized and weaponized and contorted a post-Enron obstruction of justice statute to persecute Trump supporters after January 6th. All of a sudden, these DC judges who persecuted these January 6th defendants, according to the Supreme Court's Fisher ruling, suddenly care about due process when you're dealing with the worst foreign the worst foreign terrorists in the Western Hemisphere.
Right. I got to say, though, I laugh when people keep talking about NGOs, right? Non-governmental organizations, because they're the ones suing over the fact that their government money is being cut off. So it's not as if they're really NGOs.
Yeah.
Over here we had a question.
Thank you. In 2004, Rand Herschel wrote a book about juristocracy. Okay. I've commentated and argued that that's where we are. Article 3 of the Constitution is 300 and some words. Article 1 is 4 times, okay? And Professor Turley, appreciate your commentating online very much, although my sympathies lie with Mike.
You have a crazy crowd here.
But you talk about the branches of government and the Newtonian physics, and I love that you're Madisonian, but the founders never used the term co-equal. They used the term coordinate. Don't you think we need to stop talking about co-equal branches of government, especially as it relates to the judiciary?
You know, it's a very good point, and it gets into long-standing disagreements. You know, I often, when I teach Marbury versus Madison, which is the foundation for the Article 3 courts, I do say rather, and it's not particularly popular, that Marshall sort of made that up. I mean, it's celebrated as one of the huge opinions of the time, but when Marshall said the framers just clearly believe that we are the final arbiters of what the law means, I honestly don't know the answer to that. I think that some framers may have believed that. I'm confident many would not have. I think many of the generation probably thought they were getting something similar to the English system, where the Parliament does have a role in reversing decisions. The only point is that the answer was not as clear as Marshall made out. I also agree that I'm a big believer in judicial restraint. And I believe that I agree with Holmes when he said basically, if Congress wants to go to hell, I'll send it there. They just have to be clear about it. And that means that it's one of the reasons I never wanted to be a judge, because with my philosophy, I'd be constantly doing stupid things, because if it's stupid but constitutional, I would let them do it. The problem with these cases is that it's a good example about the Alien and Enemies Act. The administration does have some strong arguments there about what constitutes an invasion. It's a really maddening debate as to, is that a reviewable term? And I think there are really good arguments on both sides about that. Strangely enough, given the length of time that that's been on the books, it's not clearly resolved. And they may have to now resolve it. But your general point, I think, is still a good one. I mean, the Article 3 has expanded in terms of its jurisdiction. It's expanded with the federal government, with statutes, with the age of regulation. It is well beyond the navigational beacons of what the framers were thinking of. That doesn't mean that it's unconstitutional, but certainly it is a different branch than I think most framers anticipated. But the federal government's very different from what the framers would have anticipated.
Yeah, although I remember I saw that, I think it was the ACLU lawyer in that case criticizing the Alien Enemies Act, saying it was an old law. And the best response to that is, well, the Constitution's pretty old too.
Yeah. I think it's also worth just mentioning that there's invasion in the Constitution, invasion in the statute. Granted, the statute was passed around the same time as the Constitution, but it's not necessarily the same analysis, and this is a statutory interpretation problem. We had 2 questions. Okay, we're going to go in this order. Ladies first, then you, and then you.
Thank you so much. This was a really great panel. My question is for Professor Turley. You said that the system is working. Obviously, there are judges that have different interpretations. People make mistakes. There's different theories, and it gets appealed. But to me, it seems that a system is only as good as the people who are sitting in it. And in a case like this, where it seems clear that a lot of them are judicial activists making decisions based on their political ideology rather than legitimate judicial theory, whether it's right or wrong, it seems to me like it's not really good faith, and I'm just not clear on how you can say it's working.
I think perhaps I just have a greater intestinal fortitude that I've developed over time because, I've seen also the Democrats suggest impeaching judges. There's a judge in Texas that has handed down some strong Second Amendment rulings. Some Democrats said that he should have been impeached. That was beyond the pale. And there are judges that push the envelope both on the left and the right. When a judge is out of control, you can ask the Court of Appeals, it's rarely granted, but sometimes it is, that judge be relieved of the case. I don't know of any judge that takes an order like that well. And you can do shots across the bow. Does that mean that you're not going to have errant judges? The answer is no, you're going to have errant judges. And I think you have seen with Trump a number of judges that are well outside those navigational beacons. They are wrong. But I do believe that the court system is sorting it out relatively efficiently. I mean, the problem are these national injunctions. Otherwise, we really wouldn't be in this position because the national injunctions, like the TRO, suddenly things have to be done and there's not a real appeal. So I do think that's something we should move on. But if it wasn't for those national injunctions, I don't think there would be as much of a feeling like the system is failing. But I don't think the system's failing. I think it's working actually pretty darn well overall. But that doesn't mean we won't have judges make mistakes. But we can't let the perfect be the enemy of the good. I mean, we need to recognize what we have, and we need to recognize how we could make it a lot worse.
I would say this, I want the courts to stop any president who's trying to steal legislative power from Congress. I want the courts to stop any president who's trying to steal judicial power from the Supreme Courts. Where I have a big problem is where these judges are sabotaging the president's Article 2 executive power, even for a second, let alone 2 weeks or 2 months. It's unacceptable.
So I had a question down here. Hold on, we get a microphone coming to you.
Yes, I'm not an attorney, but in 1850, the Honorable Henry Clay was warning us about the Constitution. Phyllis Schlafly has written in her day about the tyranny of the courts. The thing for me is this: Judge Learned Hand said, liberty lies in the hearts of men and women. When it lies there, needs no law, no constitution to keep it. When it dies there, no law, no constitution can save it. I believe our Constitution was made for posterity. It may not be a perfect document, but I believe we need to adhere to it, to its tenets as best we can. And I thank you for the panel.
Well, thank you. I don't think that necessarily required a response, but any time you get a quote from Learned Hand, it was worth hearing. We had a question back here.
Thank you so much. I just had a kind of a two-part question, but the first part is regarding nationwide injunctions. I think earlier you said that this is, you all spoke about this being like some more of a new phenomena, that it has been used a lot, like in the 20th century compared to now. I think you mentioned two-thirds of these have been issued under the first term of Trump's administration alone. I just wanted to ask, what exactly created the ability to issue these injunctions? Was this like a judicial rule, or was it an act of Congress? And then the second part question is to Professor Turley. Can the Supreme Court use its shadow docket to get more of an expedited review of whether nationwide injunctions should be permissible? Because I guess since there's like not really a party before these federal courts, they're just kind of issuing these orders. Can the Supreme Court just kind of take up this on its docket quickly?
Do you want to take the first question since I have the second one? Or? Oh, okay. National injunctions have been issued in the past, just never in numbers like this. There's some cases that lend themselves to a national injunction. If you've got a national class, for example, that is that your district is dealing with the case, but they're spread across the country, then the injunction has to reflect the class. But as the justices themselves have said, including Justice Kagan, this has gotten out of control. I mean, this is, these judges are looking at this as the first rather than the last option. And that's where I think people want to bring it back. And I think that some of the things on Capitol Hill, and I've also met with some of the committees about these options, and I think that some of them are very workable and would improve the system. The second question was, I forget, the second question was?
You said, where do they get the authority to do this?
Authority.
Oh, in terms of the authority itself, some of it comes under the laws themselves, but they claim inherent authority to have remedies to protect constitutional rights, for example. The problem is that this is sort of a modern phenomenon in terms of judges having this role. The federal government, as I mentioned, has changed. The court system has changed. Their jurisdiction has expanded, and that's expanded with it. What has helped us in the past is that American judges really are familiar with what's called the counter-majoritarian problem, which came out of Bickle in his Least Dangerous Branch book. And the counter-majoritarian danger is that what Bickle said is, look, we have these three branches, but there is one branch that's inherently counter-majoritarian. Right? It's meant to be counter-majoritarian. It's meant to go toe-to-toe with presidents, Congress, with the majority of the country, right? If you are going after some minority religion, it's designed to stand with the smallest of religions against the entire populace. So it's meant to be counter-majoritarian. But in there lies also the problem that because it's counter-majoritarian, it can create a threat to democratic process. Even in a republic, it can cause a serious threat if judges go beyond their moorings. And so until now, most judges have used that restraint, and they've recognized that even when they can intervene, they shouldn't always intervene. And the reason that's so important is because when judges intervene, the magic of the Madisonian system is really Article 1. It's the legislative process. That's where all these factions come into that, and they just fight it out, and they struggle, and it's awful, and it's not good to watch. And then out of those factional disputes comes a single majoritarian compromise. That's the magic of the Madisonian system. That happens in Congress. So you want as much as possible to go into that process to reach national majoritarian compromise. When a judge intervenes, he or she takes that offline. And most federal judges recognize that that creates instability and tensions. As we saw, for example, with desegregation, most people agreed that Brown v. Board of Education was a good decision. But it also created then decades of controversy over the role of the court in ordering it, as opposed to what Congress would do after that with the Civil Rights Act. So most judges respect that. It's just that I think that we've lost that during this period. And I'm hoping the Supreme Court is going to spank some of these judges and get them back to it.
I just want to clarify something because we have some non-lawyers who are in the audience and watching, because we've been throwing around, well, unless it's a class action. So there's a rule in Federal Rules of Civil Procedure that they have standards that have to be met to certify a class that would affect all similarly situated people wherever they are located, even if they have not been the ones to file the lawsuit. And you can appeal whether those standards have been met or not. So if there is a certified nationwide class action, everybody knows this issue is being litigated for everyone who is similarly situated in that class. That's not what's going on here. What's going on here is you have parties that are filing in front of a judge requesting relief, and the judge is saying, not only am I giving it relief to you, I'm giving relief to everybody in all 50 states, plus the District of Columbia, plus our territories where we have federal district court judges, and they get the same relief that you have, even though I wasn't asked to certify a class, and I didn't certify a class. So that is the difference why we're saying if it's a class action, okay. If it's not a class action, then you are litigating for non-parties, and there is no case or controversy pending with respect to them. Let me just ask my panelists if they have any concluding thoughts, because we are rapidly running out of time. Anything to say?
Well, one thing I want to just mention quickly, look, there's one theme that is running throughout this entire controversy and frankly almost all the lawsuits filed against the presidency. And that's what's known as the unitary executive theory. The whole issue really in almost all these cases is coming down to how much authority does the president have over the executive branch, and are all the restrictions that Congress has been putting on the president, restrictions on being able to hire and fire people, particularly at the independent agencies that have infested Washington since the 1930s. How much power does he have over that? And that's, a lot of people are saying that the Supreme Court case from the 1930s that led to these restrictions, that led to so many independent agencies, was wrongly decided. The agencies today do not even fit what the Supreme Court was talking about. And that's, I think, is what's going to be ultimately decided by the court, is that particular issue. And that's going to have a huge effect on not just what Donald Trump is able to do, but future presidents.
Any last thoughts, Mike?
I agree. The executive power, all executive power belongs to the president. And what the left calls the unitary executive theory is Article 2 of the Constitution.
Jonathan, any last thoughts?
Only to say, I want to thank my friends and thank you for a great discussion.
Please join me in thanking our panelists. Great. Thanks, Hans.
Thank you.